The day is Wednesday, October 28th. 9:03, we're going to continue the code compliance hearing, or special magistrate hearing in the matter of City of Riviera Beach versus Taylor. Where we left off, I believe Mr. Ryan was going to call his witnesses.
Yes, Your Honor. And just for the record, may I call the case in?
Sure.
Sure. It's case number CC 20-0051, property address 5281 North Ocean Drive in Riviera Beach, Florida. Property owner is listed as Joan B. Taylor Trust with Daniel E. Taylor as the trustee.
Okay.
Thank you.
Very good. Mr. Ryan, you may proceed.
Okay. Miss March Goldwire, can you hear me?
Yes, sir. Can you hear me?
Yes, very well. Thank you.
I'm sorry. Sorry to interrupt. Ms. Goldwire, I don't remember if you've been sworn in, so let's just do it just to make sure. Can you raise your right hand and repeat after me? Do you solemnly hereby, I'm sorry. I'll swear or affirm to tell the truth.
Yes, I do.
Thank you. Go ahead, Mr. Ryan. It's early.
Thank you. Ms. March Goldwire, we're here with regards to code compliance complaints made against Mr. Taylor with regards to his property on Singer Island, in specific with regards to some fill that he's placed on the property and some permits, some work that was done pursuant to permits that were issued while you were a building official with the City of Riviera Beach. And I'm going to ask you some questions about that.
Mr. Ryan, really quick, my attorney is texting me for a meeting ID number. I'm sorry.
Okay. I can tell you that the meeting ID number is 914-9248. 5797.
Okay.
And the passcode is 618172.
Okay, I'm sending that over to her. If you just give me a minute, I apologize.
Understood.
And what we'll do is we'll just hold off until her attorney gets on. I'm assuming he or she wants to be involved in this. So
thank you, Judge.
All right. So we'll just hold off for a second. Ms. Goldwire, who's your attorney so I'll know who
Rhea Chattergoon and Robin Hazel.
Okay, Ms. Chattergoon. Okay, I remember her from the previous one.
Maria, we saw your name come up. Are you just monitoring?
Hi, good morning. Yeah, I'm here. I'm sorry, I didn't have the password, the meeting ID and password, but I'm on.
Okay, thank you much.
Okay, go ahead. Welcome, Ms. Chattergoon.
Good morning, everybody.
Morning.
So back to you, Lady March Goldwire. And what do you prefer for me to call you during this proceeding? Lady or Lady March or Lady March Goldwire? You must be on mute.
Am I?
No,
Hold
no. No, I heard her. You're not on mute now.
Okay, Mr. Ryan, I prefer lady.
Okay, thank you, ma'am. Okay, so, lady, I gave you already, but before your attorney got on the line, the scope of what we're here about today. And my first question was going to be, are you familiar with the Taylor property?
I am, sir.
Okay, and you recall the permits that the city issued while you were a building official at the
Yes,
city?
I'm
Okay.
familiar.
Okay, so one of the code compliance issues that's been brought up today is an unpermitted wall. And do you recall whether or not you issued a permit for a wall on the Taylor property?
I do recall.
Okay, and do you recall whether or not you were aware at the time that you issued the permit for that wall that it was going in replacement to a fence that had been there for some 30 years?
That had been exactly my understanding.
Okay, so did you see anything with regards to the wall that was not compliant with the code, and any reason why that permit should not have been issued?
I did not.
Okay, and so you made the decision to go ahead and issue that permit for the wall?
Yes, sir, I did.
Okay, and did you, well, let me ask you this. Is a wall considered an accessory structure?
It can be. It depends. Ideally, an accessory structure would be defined as your sheds, your detached garages and whatnot. In the case where I issued the wall permit, I did not look at it as an accessory structure because I had viewed it in the vein of replacing the chain link fence that was A, deteriorating, and B, had been there some 30 years. And so short of the type of fence or wall separation, I mean, short of the barrier and its type, I didn't see it as being problematic.
Okay, and so there was no need for Mr. Taylor to have a principal use for the property in order to be entitled to have a wall on the boundary of his property?
My understanding and the way that I've always interpreted the code relative to fences and just general rights associated with property owners, most property owners have the ability to mark off the four corners of their property and also protect the property from vandalism, trespassing, those types of things. And typically you achieve that by fencing or walls. My goal for that wall was to ensure that it did not exceed the height requirements that was allowable for structures in that area, fence structures in that area, wall structures in that area, and that it was minimally invasive. And so once those two items were met, I did issue the permit for the wall.
Okay, and did you need to take into account the city's wetland preservation area ordinance with regards to that permit?
There's never a time that, at least while I was officiating, where I have not taken into consideration some of the zoning concerns. My experience as building official at Riviera Beach, I had seen previously, and I had noticed when other building officials were in the seat, that if there was very little change to the properties, there were often instances where building officials were permitted prior to me to make some decisions as it pertained to zoning, especially when there wasn't much change to the areas or the property wasn't being impacted. So in this particular instance, because the wall was being inserted in the very place, same place as the fence had been, and it was the exact same height, short of the structural component of it, there was really nothing to consider, because zoning at some point had already approved a fence. The fence had been there 20 years.
Um, and I note that sometime after you had issued permits for the Taylor property, in specific, sometime after you issued a permit for a dock on the property, that you got a memo from Mr. Gagnon on April 15th, 2019, addressing various issues with regards to the dock. Do you recall receiving that memo?
I do recall receiving that memo.
Okay, and is it your recollection that that memo does not mention the wall in any way, shape, manner, or form?
If I, I'm on this call, I have all of the records, but if I'm just going off memory, I don't believe I can recall the wall being mentioned in the memo.
Okay, and you responded to Mr. Gagnon's memo with a memo of your own, correct?
I did.
Okay, and I would submit to you that the memo that you wrote back to Mr. Gagnon is included as pages 41 and 40 in the city's exhibits. Why it's backwards, I don't know, but that seems to be the common practice with their exhibits, is that they got them out of order. But the second page is page 40 and the first page is page 41, if anybody wants to follow along.
Hang on, Mr. Ryan. Which one are you referring to? Are you referring to the code file, the permit file? Which one?
It should be the second permit file, volume 2.
And I'm just pulling it up on my phone so I can keep the screen intact here. Let me see if I can find that memo too. You're asking about my memo in response to the April 15th memo, Mr. Ryan?
Yes, it's also dated April 15th, 2019, and the subject of it is dock permit issued, permit 1900746.
Okay.
Mr. Ryan, what page is it on the file?
Page 41 is where it starts, and then the second page is page 40.
41 and 40.
Okay. Mr. Ryan, I'm listening.
That must be
I'll find it.
I'm just pausing to see whether or not the judge has been able to locate it.
No, it's not. Hang on. I'm looking at the wrong page 40 apparently.
If you're on looking at the PDF numbers for the permit volume 2, it's PDF pages 15 and 16.
My page is 15. Maybe I'm looking at the wrong one. Let me make sure I'm not on the wrong one, because these are UPS tracking records.
You might be in the code enforcement file.
Let me make sure I got the right one. Go ahead though, I'll find it.
Okay, so lady, the in your April 15 memo, although it pertains to the dock, you make an explanation back to Mr. Gagnon with regards to a 30-day time period where permits are deemed approved as a matter of law unless the applicant is given a reason why the proposed work is non-compliant. And my question to you is, would that same 30-day time period apply to the wall?
No.
Okay, and why would the 30-day time period apply to the dock and not to the wall?
Well, I think the first thing is what I've noticed when I read the violation, when I have been getting myself back up to speed as to the dock permit and its issuance altogether, there has been an omission of the fact that there was a floating home on that site. And because there was a floating home on that site at the time when I issued the dock permit, the floating home did in fact serve as a residential structure. Prior to me issuing the dock permit, when the dock permit had been submitted years before that, the only reason that the dock permit had been denied, the only reason that was listed in the conditions for denial was that the city did not permit dock structures in the absence of a residential structure. When I issued the dock permit, there was in fact a residential structure on the property. I believe it was homesteaded. I also believe that it was serving as the primary residence. And so the dock being issued at that point with a home being there kind of took care of the concern that there was no residential structure in place for it to be affixed to. The other issue was from a structural standpoint, because it was a floating home, we absolutely needed to ensure that there was something that you could wedge the floating home to. It needed to be attached and affixed, engineered to something. And the dock was the means by which Mr. Taylor proposed to ensure that, you know, the home would remain in place and intact. And so all of those reasons were why I issued the dock permit and what I was trying to communicate with and to Mr. Gagnon. The other issue, and the only reason I issued or mentioned the 30-day time frame, was because there was a tendency when the permits came in specific to the submerged land properties where they would hold the permits and not route them in such a way that they would just stall. And I had gone through, I believe it's that memo, wherein I affixed years of permit applications where permit fees had been collected from Mr. Taylor, but the permit itself had been stalled out with inaction from the building department. Because I had found myself in such, you know, it was a tumultuous space to be in while there. My concern was that I was going to get some kickback or pushback from the owners of the submerged land properties. And I didn't want to be guilty of what had happened prior, where the applications had just kind of timed out for inactivity.
Okay, but it'd be fair to say that you never got any comments from the zoning department with regards to the wall.
No, not with the wall. And I don't know, and let me be clear, I don't believe that there was a zoning comment associated with the wall, because much like all of the other parcels in Riviera Beach where the wall was going in to replace an already existing fence that had been issued and approved by the city 20 years back, there was no need to reroute that particular one to zoning, because the wall conditions, or the conditions for the wall, was that the height requirements would remain the same. I routed it to engineering. It was approved in engineering. I routed it to the structural department within our building department, and it was approved there. So once I was able to ensure that it met the litmus test in terms of structural integrity, there was no reason to send it back to zoning, short of, you know, it being a submerged land, and that was why they were asking or would have asked for it to have been reviewed.
But the wall itself wasn't
No.
extending into any of the submerged aspects of the land.
It was on the upland, and it replaced the fence that had already been there.
Okay. All right. with regards to the temporary power pole, do you recall issuing a permit for that, or the city issuing a permit for that?
I remember there being some discussion of a temporary power pole. I also remember issuing it, but I have to be honest, I get confused between the Lozman properties and the Taylor properties. I do know that I issued some permits for a temporary pole on one of the two, if not both.
Okay. And do you know, at the time that you were building official for the city of Riviera Beach, was it an uncommon practice for the temporary power pole to be allowed to remain in place until the city gave the applicant the ability to proceed and replace it with a permanent power pole?
That was not out of order. I mean, there's time restraints per the code as to how long the tent pole can be there. But unfortunately for the individuals with submerged land, it was such a difficult practice to obtain permits for whatever reason. You know, it wouldn't be uncommon for the tent pole to be there until they replaced it with an application for a permanent pole.
Okay. And is there any reason, as a building official, was there any reason to get zoning approval to allow this property to have access to electricity or any other utility?
No, it's not a practice that there's parcels in the city of Riviera Beach, multiple parcels, I believe probably more than not, where temporary poles are issued and it's never even routed to zoning. One of the duties of the building official is to typically determine what the rotation of the permit will look like. And it's not to say that you would dismiss zoning altogether, but there are instances where zoning does not come into play. It definitely would not have come into play for a temporary power pole. What had been explained to me was that Mr. Taylor was having some incidents on the property, some vandalism, some things that were concerning to him. His intention behind the pole, he told me, was to install video surveillance cameras and whatnot. And there would have been no way to achieve that without the issuance of a tent pole permit.
And in fact, isn't it true that one of the reasons Mr. Taylor wanted the camera and needed the electricity for the camera was to protect people from coming onto his property and unlawfully trimming his mangroves?
That's what he said to me. I don't know if it's true or untrue, but that was one of the justifications he provided to me. Again, I think we also have to keep in mind that there was a floating home there on the property when these permits came into play. And so, I mean, a temporary pole permit for a property that has a residential structure on it is not anything out of the ordinary.
Okay. And also there was a permit that was issued to Mr. Taylor with regards to, the wall permit also covered other improvements, i.e. some driveway aprons and some pervious parking pavers. Do you recall that?
I do recall that. What I do know is, much like the other permits for driveways and parking concerns, we sent that one over to engineering. If I remember correctly, there was some concern and some involvement from FDOT. There was an approval or something that they were looking for. Because I was uncomfortable just giving Mr. Taylor or issuing that permit to him, we had the engineering department go in and do a thorough review. And once engineering gave the approval for the issuance of the permit as it pertained to being able to park up on the property and the curb cuts, we issued the final approval. I issued the final approval as the building official. But at that point, it had already been queried through engineering.
Okay. And did you receive, or did zoning get an opportunity to comment on that driveway?
Zoning commented on a couple of those permits. It did go, but I can't remember if it was the driveway. Interestingly enough, the routing sheet associated with the permit for the engineering, for the driveways and the apron disappeared because I needed it for another case. I couldn't get it via public records request. I couldn't get it out of the building department. There were a lot of routing directories that are typically affixed to most permits that went missing pertaining to Lozman's property and Dan's property. So I can't recall if zoning looked at that one. I know that zoning looked at a couple of the permits that I issued.
Okay. And do you know whether or not, if you did receive comments from zoning with regards to the driveway, would you have taken those comments into consideration in determining whether or not to issue the permit?
Yeah, absolutely. I would have taken them into consideration. I would have also compared them to the comments that are made, on similarly situated requests to make sure that they align themselves. But yeah, I would have taken them into consideration.
Okay. And so to your knowledge, when you issued the permit, everybody had an opportunity to comment, and there were no adverse comments with regards to the driveway or the driveway aprons or the parking pavers.
We would have routed the driveway to engineering. Engineering did review it because of, that falls within the discipline. And so long as engineering okayed it, we would have okayed it. Had engineering kicked it back for comments, I would not have issued the permit. Engineering did not kick it back. In fact, they approved it, and thus I issued the permit.
Okay. And in the process of reviewing the driveway, I'll just refer to it all as the driveway permit. Did you need to take into account the city's ordinance with regards to special preservation areas?
The problem with it wasn't a problem, but Mr. Taylor was uniquely set apart from everything else. He had a court order that more or less said, in relation to fill, in relation to basically flat work that was going to be done on the property, that there was really no need for a insertion from the city, and that the city wouldn't necessarily get involved or impede his progress in terms of getting flat work permits. The problem was that, the caveat to that was he would have needed, the way the settlement agreement was worded, it was worded in such a way that so long as he didn't need approval from the other agencies, which would have been DEP and Army Corps of Engineers, as long as he didn't need those approvals for the flat work, that he didn't necessarily have to get the approval for the flat work associated with his property. The driveway was not in a submerged area. It was along the street side. And so it didn't fall into the jurisdiction of those other agencies. FDOT was involved again. And because FDOT was involved, we involved engineering and let them do the review. And once engineering approved it, we issued the final approval.
Okay. So to your knowledge and to the, as shown by the drawings that Mr. Taylor submitted, the fill that he was going to put in anticipation of building the driveway was all being put above the mean high water line and outside of the wetlands.
Absolutely. Absolutely.
Okay. So he had demonstrated that he wasn't putting fill in the wetlands, it was upland, and he had showed you a court order that said that if he didn't need a DEP approval and he didn't need an Army Corps approval, that he did not need any approval from the city for fill.
Right.
Mr. Ryan, let me jump in real quick.
Yes.
Just want to tidy something up. Miss Lady, you mentioned FDOT. Can you, just for the record, say what that is?
Yeah, Florida Department of Transportation.
Okay.
I'm sorry.
No problem. I just wanted to clarify just for the record. Thank you. Go ahead, Mr. Ryan.
And Ms. Goldwire, Lady, on that topic, do you know whether or not Mr. Taylor was able to demonstrate to you that he was in compliance with the Florida Department of Transportation and regulations, and that they had approved the driveway aprons that he wanted to install?
Because it was flat work and I wanted to be certain that everything was on the up and up, I did not take it upon myself to, oversee whether or not he was in compliance. That is why I redirected it to engineering. That was in their purview. And if engineering was able to mesh out whether or not he was in compliance, which they would have been required to do prior to issuing the approval, then we were good. That is why I sent it there. It came back with engineering's approval, and thus we issued the final permit.
Okay. So it's just your assumption that based on engineering's review and approval, that they had made a determination that what Mr. Taylor was doing complied with FDOT regulation.
Right. It wasn't just an assumption, though, Mr. Ryan. I spoke with the engineering department. I spoke with the individual who reviewed the permit. They, in fact, told me they had met directly with Mr. Taylor, reviewed the items as well prior to issuing the permit. And so it was that, coupled with the fact that they signed off on it, that made me comfortable with issuing the final permit.
Okay. And so you never did issue any permit with regards to the fill that Mr. Taylor placed on the property, correct?
No.
Okay. You made a determination that no permit was required from the city for that work.
I did.
Okay.
And it wasn't a determination that I made without zoning. I did talk to Mr. Gagnon about it. His concern was that the settlement agreement, the way that it was titled, because it mentioned Joan B. Taylor and not Mr. Dan Taylor, that it was it wasn't applicable to what we were doing. But the order and the content of the order said that it would, it followed the property.
Okay.
And so once we had that kind of back and forth, I took it through the same process that we would take any other property similarly situated to Mr. Taylor's, and allowed them to go through the process that way.
So Mr. Gagnon's concern was that the order only ran in favor of Mr. Taylor's mother.
Right.
But you had directed him to the language in the order that directly expressed that it would run to the successor owner.
Yes.
Okay. All right. Now, I know we already got into the dock permit to a great degree, so I don't have much left there. But at the time you issued the dock permit, it was your understanding that Mr. Taylor had a principal use and had eliminated the objection to the dock permit that the city had raised in 2014.
So with the dock permit, the 2014 concerns, 2012 concerns, and I believe it was a 2010 set of permits applied for at that time. When the request came in, when it did from Mr. Taylor, I believe the fourth time, there was a residential home in place. The conditions for it not being issued before was that there was no primary structure that the dock could be affixed to. When we argued that, and I did have that discussion with Jeff, we talked about the other dock nearby that also didn't have an accessory structure. And I was trying to get some understanding as to how it was different for Mr. Taylor. Even if the residential home wasn't in place, you had in that same vicinity another dock that had been built more or less as an accessory dock. It also was a 30-foot long dock, so it almost took on the liking of a commercial dock in a residential zone. There was just so many different inconsistencies as to this particular dock permit. I was concerned. The other thing was we were getting bombarded with emails from the public who didn't want the floating home there. But when their argument became that there was nothing to secure the floating home and that we were moving into a space, or what would we do when it was storm season, issuing the dock permit for it to be affixed to just made sense to me.
Okay, so there's no question in your mind that when you issued the dock permit, Mr. Gagnon was well aware of the prior denial based on the lack of principal use only.
There was also another denial that one of his subordinates had issued. Ann DeVoe was the plan reviewer that got or picked up, because we didn't route. When the permits came in, I know I made every effort to put the permits in a central location so that zoning could get them. And we didn't pick and choose who it went to in zoning. In this particular instance, when Mr. Taylor brought his permit in and we got past the fact that he did indeed have a residential structure, getting rid of the last condition, Ms. DeVoe reviewed the plans and basically said, you know, I need an updated survey, or it needed to be signed and sealed because the one he had was relative to his last request. And we had implemented some new rules that said updated surveys were required. That was the only objection that she made from a zoning perspective. Because I had witnessed, and at this point, Mr. Taylor had brought in literally bins of information that pointed to his inability to secure a permit. I had spent a couple of days going through all of that stuff. Once we got an updated survey for the very thing that Ann had already looked at, and we were able to eliminate the ideology that there was no residential structure, which was the other condition. Technically, all of the conditions had essentially been met. And so there was no reason at that point not to issue the permit. And so not only did I ask them to issue the permit, I also asked the building department, the clerk, to research refunding the other permit fees that Mr. Taylor had indeed submitted that had not been paid. We were only able to, I believe, get him approved for 50% of it because of the time associated with it. But those were the actions that I took on the dock permit and it being issued.
Okay, so if I understand your testimony correctly, you got two comments from zoning. One was a request for an updated survey from Ms. DeVoe, and the other was concern over the principal use because there hadn't been one previously. And both of those comments were overcome, and the 30-day period plus whatever days were told had run. And so you determined that as a matter of law, Mr. Taylor was entitled to the permit.
I did.
Okay. And did there come a time when Mr. Gagnon insisted that you revoke or rescind the permit for the dock?
We had conversations about the permits being revoked and rescinded. I will go as far as to say, I believe Mr. Gagnon was aware of the fact that based on a meeting we had had in April 5th, that if indeed I issued the permits, that I would not revoke them. So the conversation, it had been implied that if we issue them and I take them through the process, I'm not going to revoke or rescind the permits, unless there's, actual cause to do so. I didn't see the further developments until long after I left the city with the involved reasonings as to why they could not get the permits, because I believe my memos laid out solutions and remedy to what they presented to me as reasons why he shouldn't have the permit. Off the record reasonings were, if you give him the permit, it's going to set the precedent for the other individuals in the submerged areas to then also get permits and develop their land. There have been admissions that Mr. Taylor was uniquely different, but it wasn't necessarily something that they wanted to put into writing. And so just aggravated with the entire process. And I don't know that everybody had access to the same information that had been provided to me. Seeing emails dating back to 2010 and others where there were just dialogue going back with former council people saying, we're just going to say this is an environmental area, hold off on the permits, and watching what I could see in the manifest as to how those permits stalled. I just didn't want to be involved with that. So yeah, I did move the permits forward. I didn't see any reason not to.
Okay. And with regards to the demand to revoke the dock permit, that was unique as to the dock permit, correct? There was never a demand that the permit for the wall or for the power or for the driveway to be revoked.
In our April 5th meeting, our conversations primarily centered on the dock. But it was really difficult for them to have me revoke those permits because, unlike now, the floating home was in place. And so it was a very different situation then when we were having the conversations and now.
Okay. And with regards to the timing of principal use and accessory use structures, it seems to me to put the cart in front of the horse to require a floating structure to be on site permanently prior to the construction of the dock, because obviously without the dock, you're only at anchor and your access to the floating home is very limited. Whereas, a typical land-based construction, you might have a house built before you build a dock. But my question here is that, it also seems to me common sense that if a person came in and got a permit for a house and got a permit for a dock, is there anything in the city law that would prevent that person from building the dock first, and while they had easy access to the rear of the property, and building the house subsequently, but in a timely manner?
So typically how we would address a situation like that, if there was a proposed a permit issued for a dock, you would need to demonstrate in the submittal for the dock that you intend to build a house. We need to see those plans. We want to see how the two tie together. So the code or the ordinance as it's written, whereby you need an accessory, you need a primary structure And then only then can you have an accessory structure like a dock come into the consideration. Is not far-fetched. You don't want people just building docks without there being any reason for them. But again, in this particular instance, there were two things that stuck out in my mind. There was a residential structure there because the floating home was in place. But in addition to that, just up the street, there was a 30-foot, I would classify it as a commercial dock constructed with no permanent residence attached to it. And so either way, I looked to try to proper, explanation as to why I would not issue the permit. You had those two things to make consideration for.
And that other dock that you're referring to is into the same lagoon area that Mr. Taylor's proposed dock was.
It is. It is. It's not far. It's in the same lagoon. If I'm not mistaken, I believe it belongs to Mr. Davender Cott, and he was our engineer for the building department at some point, issued the permit to himself. He would have been familiar with the language in the ordinance that spoke to its inability to have one without the other, and he had one. And so it was just...
And there is no principal structure on his property, is there?
No, his home is located on another parcel, and I believe there's another structure in between it.
And in fact, he doesn't even own the upland where that dock comes ashore.
I can't speak to whether or not he owns it. I'm not familiar. I believe that your statement is true, but I'm not comfortable saying that 100%. What I am very sure of is it is not on the parcel. The dock that he has is not on the parcel where he owns the residential structure. And all of that is happening in the same lagoon. And so the question became, why is this allowable here? Why would you have me deny it here? We have a court order that says XYZ with the other permits. Why am I being pressed to not issue the permits in this capacity? And now we have this guy who has a floating home banked on his property, needing a way to secure it. What are we doing about the dock? Once I was able to determine that the conditions that had been initially laid out to me or initially laid out to Mr. Taylor were met. He did have a residential structure. The survey was updated. We issued the dock permit. I issued the final approval for the dock permit.
Okay. I've got one more topic that I want to touch base with you on. There's been some prior testimony in this case with regards to a meeting that occurred long after you had left the city in November of 2019, and a package of documents that was then provided to the building official, Mr. Durrani Guy, in response to that meeting that were provided in December of 2019. And the testimony from Mr. Guy was that he had received the documents, and the testimony from Mr. Gagnon is that he had never received the responsive documents. Does that strike you as odd based on what you know about how the city building official's office works or building department works?
Objection, Your Honor. Ms. Goldwire March would have no personal knowledge of a meeting that occurred in November 2019, as she was no longer working for the city. And his question is pure speculation on her part.
Yeah, I'm going to sustain that.
I would like to respond to the objection for the record, Judge.
Go ahead.
I didn't ask her what occurred in the meeting. I didn't ask her whether she knew what occurred in the meeting or just speculated about. I asked her about the procedure that the building department used for routing documents. And that is something she would know about.
But you can ask
That
her.
said,
You can ask her that question with
okay.
relation to her time at the city. You can't ask her that question in speculation of what may or may not have happened after she left. She wouldn't.
While you were there, lady, if documents had been received in response to Mr. Gagnon's memo of April 15th, what would have been the building department's process for routing those documents?
So typically the documents come into the clerk. The clerk looks at the documents. The clerk is trained to, based on the description of the scope of work, issue or route the permits so that they can be reviewed by the necessary disciplines. If the clerk is stumped on the routing rotation, she'll then refer to the building official to give her some guidance as to what departments they should go to and where. Typically, to keep it very, very fair, they would, at the time when I was there, once they determined the routing, they would put them in the box and we allow the plan reviewers to come in and grab what they want. It's typically done in date order fashion. That happens every day as they're received, or at the end of the day or some segment of the day. My observation had been there would be particular permits that were pulled. Sometimes they would be stalled. They would sit with some reviewers. In this case, they would sit with or had sat with the interim director. And then the days would just kind of roll by. And so while I understood the code and I understood that there was a caveat to that 30-day rule, which said if there were special circumstances, it could stall out. Because the special circumstances that they kept mentioning were issues that we had already resolved, I considered those conditions having been satisfied and moved from there. The routing process now, Attorney Godot is absolutely correct. Things have changed. I don't know how they do it, how they done it, and the intention behind it. So it'd be hard for me to comment on that. But while I was there, that was the process.
If hypothetically, if the requested documents had been delivered by the applicant to you, would it have been your practice to route them to the clerk and make sure they got to the clerk so everybody else would have access to them?
So I was the building official. I had been witness to what was going on with that particular property. When the survey or the conditions came back from a representative from the zoning department, wherein their only concern at the fourth submittal was the fact that the survey, which was identical, but simply needed to be updated. When it came in, I directed the clerk to bring it to me so that I could verify that it had been updated as the zoning representative had requested, and the permit was issued. That was not a typical process, but that was something that was in and within the purview and the discretion of the building official. And so that was the way that I handled that particular submittal.
Okay, I have no further questions for you, ma'am. I appreciate your time today. The city's attorney may have some questions for you to follow up.
Yes, sir.
Go ahead, Ms. Godot.
Thank you. And lady, since I'm gonna call you lady, feel free to call me Christy.
Okay, Christy.
All right. So you said you have all the records in this case with you. I want to go through some of those records.
Okay, now let me say this I'm not Zoom proficient, so I'm most comfortable pulling these documents off of the computer that I'm actually sitting at. As I pull these down, what happens with this whole thing? Or do you still see me? Am I gonna log out? Like
No. I think that the intent was to give everybody the exhibits so that we wouldn't have to share screen. So
okay.
I'm doing the same thing you're doing. I'm looking at the documents on my computer.
Okay.
And they won't show up on Zoom. So your document should not show up on Zoom unless you use the share screen function.
Okay, so I can't see you guys anymore. I'm gonna get to it. Let me open up the file that I have while you get ready to give me questions. I'm sorry about that.
Sorry, I was on mute. Ms. Godot, which file?
We'll start with the city's permit file, volume 1.
I got a question. Did they email that file to us, me, maybe?
They should have. If not, I can email it to you right now.
If you do that, that'll make it easier for me.
Not a problem. What's your email address?
Lady A Goldwire at gmail.com.
All one word?
Yep. First name, middle initial, last name.
Lady A Goldwire.
At gmail.com.
Okay.
Would you please CC me on that? So I'm looking at the exact same thing.
And does your attorney also want me to CC her?
I'm probably, yes, I'm sure she would. She may have all of it. But...
This is Robin. I'm one of Lady's attorneys. I'm here. Yes, if you can send that to me too, that would be great. My email address is rhazel@hazellawpa.com.
And I can get it from Robin. This is Rhea Chattergoon.
hazellawpa.com. Okay.
Thank you.
So what I'm going to send everybody initially is the permit files. There's 2 volumes just because I didn't want to create a bounce back issue. So I'm going to send the permit file volume 1 first. And I've just sent that, so let me know if y'all get that. And then I'm going to send the second volume next. It might take a little while to go through because it's, I think, like 20-something pages. And I just sent the volume 2 for the permit file.
I haven't gotten it just yet, but I'm gonna grab my glasses. 40 eyes have indeed kicked in. Hold on.
Okay.
Okay, I have volume 1.
Okay, that's good news. Let's wait. I want to make sure that everybody else has received it so that we don't have any issues.
I do.
Okay.
pages did you say it was, Christy? Because when I get to page 7, it
Oh, I just said
let me
we were
try
going
to
to go through
download it again.
document. I'm not sure uh, if ladies attorneys have received it or not. Ms. Hazel, have you received it?
Yes, I just responded to your email. I received them.
Okay.
Thank you.
And Ms. March, have you received volume 2 yet? All right. Well, if everybody's got volume 1, we can start going through volume 1, okay?
Yeah, it's loading. I see, for whatever reason, when I get past 7 on the first volume and 11 on the other one, it kind of stalls out, but hopefully it opens up.
Did we lose Ms. March?
I think we lost her. There she is.
Okay. Yeah, I'm sorry.
That's
I was
okay.
trying to download the documents. It's giving me a fit past page 7 on the first volume and 11 on the second one. So I'm gonna try to work with, hopefully it'll do what it's doing and I'll figure it out.
Okay. All right. Worst case scenario, I can try to work magic with sharing the screen so you can see it. So if we run into an issue, I'll do that.
Yes,
All
ma'am.
right, so the first page of volume 1, if you can see that, that's the dock permit application?
It is.
Okay. And do you recall what the size of this dock was?
Off the top of my head, I do not. I would have to refer back to the specs that they submitted with the application.
Okay. If we move to page 4, there is an orange sheet. Can you describe what that sheet is?
It's the routing sheet. It's one of the routing sheets associated with this permit because I believe there was another one, but it is a routing sheet.
All right. And this is for the dock permit?
Yes.
Okay. So up at the top there where it says building, yes, and there's a date in and then a date out and some initials. Are those your initials?
The orange?
Yes.
Yes.
Okay. And then if we scroll down to the bottom of that same page 4, is the very bottom, sign off by, are those your initials at the bottom?
It is.
Okay.
I'm sorry for the dog. She's a little.
Okay, it's all right.
Rambunctious.
All right. So when you were the building official, did you require owners to sign off on their building permit applications?
I don't understand the question, Christy.
Well, if when you were a building official at the City of Riviera Beach, if I applied for a building permit, would I need to sign the building permit application?
You do, unless you have an owner rep. There's processes associated with that. In addition to that, certain dollar thresholds don't require you to physically sign it. The contractor can do it for you. But yeah, in most cases, you would sign the application.
And do you know, in this case, did Mr. Taylor sign off on these building permit applications?
I presume-
Objection, Your Honor. Best evidence, the document speaks for itself. There's a signature block on it. That's the best evidence of whether Mr. Taylor signed off.
Your Honor, I'm asking lady for her to recall whether or not Mr. Taylor signed the applications.
Objection, Your Honor. Relevance.
Judge, I'm sorry. She can testify as to what her knowledge is, and obviously the documents and evidence. So obviously I'm going to look at that. So you can proceed.
Lady, to your recollection, did you have or did Mr. Taylor sign off on the permit applications in this case?
Mr. Taylor submitted the permit application as you see here, and it was signed. Now, whether he signed it or not, I don't know, but typically it's notarized. So I presumed he signed the application.
And is the notary is based on a dollar threshold, correct?
Yeah, I think after $2,500, there's a requirement. I think it says that on the application. There's a requirement for a notary.
And do you recall if the permit for the wall, pavers, driveways, aprons, and fill, what the dollar value of that permit was?
I do not. I could, if you have that application, I could see it and I could tell you. But the clerk.
Excuse me. Let me objection. I want to get my objection in. I apologize. The question assumes facts not in evidence, Judge. She asked about a fill permit application, and there was no fill permit application. There's been no evidence that there's been a fill permit application. There was a wall, pavers, and driveway aprons permit application. So if she wants to rephrase the question so that it reflects the evidence, that would be fine.
I'll sustain it on those grounds. And Ms. Godot, if you just tailor your question to whatever is relevant.
Okay, well, I'm just asking for what she recalls in terms of the permit that was issued that included the walls and what the value of that was.
Yeah, I think that, yeah, I understood that. I just think.
I don't. If I see the application, I could confirm what the values were, but off the top of my head, I cannot.
Okay. But if that permit was valued at over $2,500, they would have had to sign it and notarize it.
Typically, yes, absolutely.
What would be the exception to that?
If it was owner builder,
did Mr. Taylor apply for an owner builder permit?
I can't remember. He had so many permits in old, new, expired, in between. I would really need to see the routing sheet and the application.
Okay, when we go back to page 1 to look at the permit application form for the dock.
Okay.
Was this an owner builder permit?
This is not an owner builder permit.
Thank you. All right, when you were the building official at Riviera Beach, you would, in your role, review permit applications for compliance with the Florida Building Code?
Yes.
And especially if something involved structural components, you would look at the applicable Florida Building Code to determine that it complied with the building code.
That's one of the things we would look at and make consideration for. Yes, ma'am.
What else would you look at?
You would, from time to time, look at the ordinances. From time to time, we go through the Muni Code, which also embodied the ordinances. There would be instances where we would have to refer back to, historical knowledge associated with the different properties, depending on the situation. I mean, there was a lot of things that would come into play, but we were primarily dependent on the building code.
Okay, and so as the building official, there's a lot of things you look at in deciding whether or not to issue a permit.
Yes.
Now, in your time as the building official, were you authorized to issue zoning approvals?
We did not do zoning approvals. There are some examples in incidents in the code, in the history of the building department, myself, the building officials prior, where it's not uncommon to have the building official issue or do zoning review. It's part of the way and what we're trained on. It's not my particular area of expertise.
Okay, so when you were there as the building official, did you authorize any approvals for permits under the wetland preservation ordinance?
Yes, there's been a few.
And can you describe those, please?
I issued the permits for Coulter Cast, which is on the opposite side of the street. There were some serious wetland concerns there, but we ultimately kind of worked through it. They built a high rise. It's kind of in the same vicinity. There have been approvals it is in the same vicinity. It's across the street.
Well, let me stop you there. So that high rise never received a zoning review?
No. It received a zoning review, but there were accessory permits associated with it that would have also probably gone through zoning, but because they had already had the clearance, if they came in and made ask for additional items in addition to their master permit, rather than take them through the process of zoning, if it was something that had been done prior on another property, there's been instances where I've issued a permit. I believe they had a gate entrance that I issued that I didn't take through zoning. I believe there was, I can't remember exactly, but yeah, there's been instances.
That development had a zoning approval.
I'm sorry?
That development, the high-rise development, had a zoning approval in the process.
It did have a zoning approval. You get a site plan approval from the city council. And there was some zoning approvals that did come into play, but there are other asks associated with that permit that could be argued would go through zoning that did not. And you were asking me whether or not I've ever issued one in that capacity, and my answer is yes.
Okay. Have you ever issued an approval of a building permit that required a zoning approval that you did not obtain?
Yes.
Have you, in doing that, can you describe the situation where you did not obtain a zoning approval?
Where the circumstances were similar, where I could identify another property that had some of the same things going on. I guess the best example would indeed be this wall permit, where it merely replaced a fence, same length, same height. The only variation or differentiation was the composition of the structure. So we went from chain link to cement wall. And then because of that, I would have again gone through a structural review, which it did. And there's been some on the west side of Riviera Beach that I've issued. There's been some on the west side that previous building officials have issued. Our cold storage project, that one went all the way through. All of the disciplines were approved by a single building official. They weren't routed until we came on board. And so it's not out of the ordinary for a building official to do a superficial zoning review if it doesn't impact life safety.
Okay. I don't know if you can look at it now, if maybe your computer has had time to upload it, but can you go to page 24 of the permit file, volume 1?
Let's see.
I'm sorry, were you on volume, which page on volume 1?
Page 24, permit file, volume 1.
Is this the temporary poll?
Yes, it's in
Okay.
blue. It should be in blue. Does it show up in blue on yours?
It does, Christy.
Okay. Based on this application, was this an owner builder permit?
This is not a owner builder permit, no.
And it appears, even though you can't confirm, that Mr. Taylor signed off on this?
Yeah, it does.
Okay. All right. Have you received volume 2?
I did. Hold on a second. Let me see. Yeah, I have volume 2.
Okay.
Can you hear me?
I can. Can you hear me?
I can. I'm sorry. I can't tell. I can't see you because I'm looking at the document. I don't know how to split the screen.
Okay. All right. So when they submitted for the dock permit, that was back in March of 2019.
Yeah, that had been the 4th time they had submitted for the permit. Right, March.
Right, but what you were considering in March of 2019 was the permit application we just looked at.
Right.
Now, when you reviewed their submittal, what edition of the Florida Building Code did you review it against?
2017.
Okay. And the Florida Building Code goes on a 3-year cycle?
Kind of, sort of, yeah. Yes.
Right. So right now, aren't we headed into the, what, 7th edition?
2020 cycle, yeah.
Yeah, and so that, the 7th edition becomes effective at the end of this year, right?
I'll have to verify or confirm, but I do believe so.
Okay. Okay, so when you were the building official and a building application came in, you would automatically or not automatically send it for a zoning review?
So the clerks route it, not me. The clerks typically route it unless there was an issue. I will say on these permits, because the clerks have been familiar with kind of the up and down and everything going on with it, they probably would have asked or reached out to me to find out, or at least let me know that it was in rotation.
Okay. And when the permit application came in for the dock, did any other permit application come in for that for the floating home?
No, the floating home had already been situated there. What did happen was it showed up one day. No, there were no permits for the floating home. Because the floating home was already engineered and assembled, the permit that was required was the engineering attached to how it was going to settle or how it would be anchored.
And was that documentation submitted with the dock permit application?
No, we were aware that the floating home was there.
So were any documents submitted that would show how the floating home was going to be attached to this dock?
No, that was why the dock was being requested, and that was why the dock was being issued. Because the way the code read, or at least based on the way that I had interpreted it, since the house had already been manufactured and brought in, they weren't, if they were going to add any scopes to the floating home, electricity, plumbing, that would need to be permitted. What it did say is you could get around the whole concept of the floating home needing to be permitted itself outside of those caveats, but you did have to supply engineering that would support how that floating home would be anchored. And that engineering was embedded in the request for the dock permit. So if we have the dock permit, we would also then have records showing how this floating home was to be attached. You would have the dock permit approved first. Once we got through getting the dock permit issued, Mr. Taylor would need to submit how the floating home was going to be attached. Okay.
So in looking over the records related to this dock permit, would you find it odd that there's no reference to a floating home?
There should be some references in terms of the ask. The problem is there were tons of emails centered around the floating home, what was to be affixed to the floating home, but with much of the City of Riviera Beach documents, you know, I don't know where they are. They've kind of disappeared into cyberspace, but there was extensive conversation about the floating home and why the dock was required, the floating home and why they couldn't tow the floating home because it wasn't governed under the maritime laws, the floating home and why, you know, we would involve DEP and Army Corps of Engineers and why we wouldn't. There was a plethora of communication back and forth relative to the floating home. The dock, though, was the first step in getting the floating home anchored to address some of the concerns that we were getting via email from the public, and then to move us along in the process of actually getting and ensuring that the floating home met code. The objective was to essentially get the dock in place, and we were going to go back. We needed to inspect the floating home to ensure that there indeed weren't additional disciplines. There had not been work done to the house, because then it would have triggered the requirement for more permits. But we never got to that point because the dock permit itself became so contentious.
And do you recall a time frame that the plethora of information came in regarding the floating home?
It would have been, I would say it started hyping up around January, but that was more or less for Mr. Lozman and his concerns for bringing his floating home. I'm not quite sure when Dan actually brought the floating home, but I'd say the window of time would have been anywhere between, it would have probably begun around February with Mr. Taylor, I'm guessing.
Okay, and let me just back you up. We're talking about 2019.
Yeah.
Okay, I just want to make sure for the record that it's clear.
Yeah, I believe so.
And when you refer to Dan, you're referring to Mr. Taylor. Okay, all right. So when the dock permit came in, it was your understanding when it was initially submitted that it was for the floating home?
It was to anchor it, yeah. Yes, okay. Yes, ma'am.
And then in your review, you would have referred to the primary structure as a floating home?
I would have referred to the floating home as a primary structure.
Okay. And then in the records we have, based on your testimony, the way this transpired is they applied first for a dock permit for the floating home, and then they were going to come in with any necessary permits that they would need to attach the floating home to the dock.
We were going to, or they were going to come in for the dock. The dock was to have been installed, constructed. Then there was supposed to have been engineering subsequent to that, attached to how that house was going to be affixed to the dock. In between that, we were going to go out and conduct an inspection to make sure that Mr. Taylor was within compliance in terms of not adding to the home, that what he had brought in was what was there, it was staying, and that it wasn't going to be amended.
Okay. So at the time of your review of the dock permit is a standalone permit, which will then be supplemented by the floating home.
Right.
Okay. Now, in the memo that you talked about, the memo you drafted that you spoke with Mr. Ryan about, You talked about this 30-day time frame. Can you tell me what statute that's from?
I might have cited it in something that we wrote. I know it's out of chapter 553. That is so the chapter itself is so voluminous.
Okay, let's go. If you have the permit file volume 2 up, let's go to I believe it's page 44 and 45, which if you're looking at the PDF, it's page
Okay.
26. Let's see. No, I'm sorry. That's wrong. It's page
16.
Yes, thank you. 15.
And this is volume 2?
Yes, ma'am.
The second page is 15. The first page is 16.
Right.
Why does mine say 26? What is it exactly?
It's your memo to Jeff Gagnon, dated April 15th.
Okay, I have it. I think this is volume 1 for me.
Could be volume.
But anyway, I have it. You said page 16.
All right, so the 30-day plan review that you're talking about, according to this memo, is from section 553.79.
Yep, and 79.1. I mean 79.791.
Okay, so and this is dealing obviously with the dock permit, and in the dock permit, did Mr. Taylor use a private plans reviewer?
No, he did not.
So if 553.791 deals with private plan reviewers, it would not be applicable.
There was something in it that was applicable. I don't know if you'll give me a minute to try to refresh my memory and read through this entire memo. I could have been referring to 0.791 for the purpose of Mr. Taylor as a recommendation for Mr. Taylor to be able to utilize the private plan review process or private provider process, because he was running into such an issue with the city. But I need to go back and read through this memo to try to get the context.
All right, if you want to take a second and read through the memo, we'll wait.
Okay, thank you so much. Okay, I'm done, Christy. I apologize.
That's okay, not a problem. It's been a while. So the citation to 553.791, were you just giving that to Mr. Taylor for his FYI?
I was giving it to Mr. Taylor and throwing it. This memo didn't go to Mr. Taylor. I was giving it over to Jeff and Don for the purpose of, you know, putting it out there that remedy would be available to Mr. Taylor.
Right. And so if he were using a private plans provider, once a private plans provider does a review and submits it to you as the billing official, then you have—
Objection, Judge. She's characterizing a Florida statute. She's, you know, you're the expert on the law here. She hasn't put in the statute, and she hasn't established what the statute says. So the question assumes that the statute is her understanding of it, and I think that's an unfair question.
Your Honor, lady has cited to 553.791 in her memo to Jeff Gagnon, certainly in her purview as a licensed Florida building official to have knowledge of what the private plans review statute says. So I'm simply asking her knowledge of that statute that she cited to in this memo that we're looking at.
If she wants to ask her what her knowledge is of that statute, that's fine. That's not the way I heard the question. It was leading as to what the statute said.
I'm going to allow the question. The memo refers to it specifically, and I kind of think we know what we're dealing with here.
So, lady, under the private plans review statute 553.791, if you use a private plans reviewer, they submit the reviewed plans to you, and then you have a 30-day turnaround time frame.
Well, the 30-day time frame is separate from, and that statute's referenced by 553.79. The mention, or my intent for mentioning the 553.791 was to kind of pull their coat to the fact that, you know, the process doesn't even need to or have to go through us. There's an opportunity, if we don't get this right, for it to go to the private plan reviewer. And that was the sole intent of mentioning 0.791.
Okay, but to your recollection, Your Honor, did we lose you?
No, I'm here.
Okay, you just moved like on my screen, like from one side to the other. So I just wanted to make sure. Okay.
Okay, I have some housekeeping to deal with here.
Okay, all right.
But I heard everything.
Okay. So, lady, from your recollection of this dock permit, they weren't at this point using a private plans reviewer.
They were not.
Okay. All right. So you mentioned on direct a conversation on April 5th with Jeff Gagnon and others. Who was in that meeting?
It was myself. Hold on a minute. My dog just somehow broke loose. Go.
No worries. No worries.
It was myself, Lionel Busby, Dr. Botel. It was Terrence Bailey. It was Bovell Richards. It was I believe a representative from Fire. It was there was also Mr. Gagnon. There was also someone from police. I believe it was Mr. Lewis. I forget his title, Captain Major Lewis.
Josh Lewis.
Yes. And then there was myself, and it was someone else, Mr. Bailey.
So a big meeting.
It was a big meeting.
Okay. So at that meeting, did you talk about this dock permit application from Mr. Taylor?
We did.
And what was the discussion about?
It was, at that point, Ms. Botel had come to the meeting and had implied that she wanted us to, she was going to be working with DEP, was her exact words, to see, and making some phone calls to see if they could rescind the permit. And at that point, in the conversation, I was explaining to them all of the reasons why I believe that the permit should be approved, all of the reasons why I had approved it. I had made mention of the fact that that permit had come in around March 7th and it was still stalled.
Let me stop you
yes.
there.
Yes.
This meeting was on April 5th. You didn't issue the permit till when?
I'm not exactly sure of the date. When I think the April 15th date was when it was issued, because
Okay.
the memo talked about the fact that it was going to be issued. I think
your memo from April 15th?
Yeah, I think the second page says basically I'm issuing the permit because it's now the 15th. We talked about a resolution to this, to come to a resolution for it by the 9th in the April 5th memo. And since that hasn't happened.
Wait. What April 5th memo?
There's an April 5th memo that you should have. I left the meeting abruptly once there was discussion about. So there was this discussion in this meeting that if I in fact issued the permit, Jeff was going to compose a letter that basically would trigger a zoning in effect and put that whole set of properties into a zoning of effect. He would issue an administrative memo that basically prohibited any issuance on the permits and would establish a memorandum. A moratorium. The moratorium was kind of resulting in my insistence to issue the permit. And so as the conversations got heated, someone had mentioned to Jeff that to a certain degree, and because the thresholds had been met, he could not interfere with the duties of the building official. And then his objection to that was, okay, well, then I'll just call it zoning. We'll go into a space of moratorium, or at least I'll start the process, and then that will prevent anything from happening. And then my argument became, well, if you do that, the date on these applications will precede that action, and so it won't impact them. And it just got super complicated. I left the meeting based on, feeling as if, I forget the word that I used. They didn't like it, but I didn't like that we were having conversation about what our next move would be to not issue permits. And so I left and I drafted a memo that laid out everyone in attendance. I mistakenly omitted Mr. Bailey. It was an error. I was trying to do it as soon as I got out of the meeting so that it was fresh. And I immediately sent it to all of upper management with regard to what my observation in that meeting had been and what my intention was going to be if in fact we got to the end of the 30 days. So this April 15th memo was in response to either an email or a memorandum that Jeff had written me. And it basically, that was my retort to it.
All right, so your April 15th memo was in response to Jeff Gagnon's April 15th memo, where he laid out the zoning concerns, and then you issued these permits.
So the problem with the zoning concerns
Wait.
Yeah,
that was the process.
Say it again, because I want to make sure I answer you just right.
Jeff sent you a memo with the zoning concerns. You then issued your memo as to the Florida statute that we just talked about, and then you issued the permit.
So no.
What was the process?
The process was Jeff issued a memo with the statement that he would tell us what the concerns were in the near future. I called that out in the letter. And my response to that was a memo laying out the citation in the statute that said, you specifically have to state what your concerns are. You cannot now toll the permit until you come up with issues in the near future. Okay. So I'm issuing the permit.
All right, so let's go. If you have the permit file volume 1 back up. if we go to page 14 of that, page 14 of that, there's an email from Jeff Gagnon to you and others. Do you see that?
I do.
Okay, and what's the date on that email?
That date is April 9th.
Okay. So he sent you, we all can read the email so we knows what he's saying, that the permit's under review. And this is in response to your April 5th email. And what's that about, the April 5th email?
So the April 5th email, which triggers then this email was in response to the fact that the permit, I was verifying from the permit based on a conversation that I had had with Mr. Taylor relative to his frustration that this was now his 4th time having remitted fees for a permit and that he was being intentionally ignored. I requested at the start of this email on April 5th, post the meeting I had already had with all of the individuals involved, I wanted Clarice to confirm for me what the date was that the permit came into our office. When did we do intake? Clarice in this email is confirming that it was created on March 7th. And then she indicates that there were some issues with the application, that it had not been completed correctly, and that the customer was told to return with the corrected information. She then confirms that that's standard procedure. Jeff on April 5th, post this meeting, said, please provide the intake information, the application date, the routing sheets, all of the stuff that I'm telling you now we don't have. I then respond back. He tells me, lady, the application is currently under review. From his initial planning, from his zoning observations, insufficient evidence was provided with the submittal and deficiencies exist. But Jeff also knows that the code requires us to list the deficiencies. And the fact of the matter was, the only deficiencies that have been presented to me and the people reviewing the permit from zoning was associated with the fact that there was a survey that needed to be updated. That's on page 18, I believe, of these documents, where his zoning representative only calls out the fact that it had not been updated. That was the only condition that they listed.
Now, why would zoning want an updated survey?
We have
Objection, Your Honor.
implemented a
Speculation.
practice for all of the, oh, I'm sorry.
Excuse me, ma'am. I said objection, Your Honor, calls for speculation. If she knows why zoning needed it, that's fine, but
I think that's what
she
I'm
hasn't
asking.
accomplished
That is what I'm asking, because here's someone who's saying that they've, approved things for zoning. So she should have knowledge of why zoning would need a updated survey.
For this particular instance, ma'am, zoning only requested the application or the survey to be updated. She tells you why she wants it, essentially, or she references it. But we had just recently made a unilateral rule in the building department that all surveys needed to be within, I believe, 2 years or 3 years. And that particular survey, although nothing had changed on it, did not meet that threshold. That was the reason for her request.
So her request, which is noted at page 18 of the permit file, volume 1, in the orange routing slip.
Right.
Which
It
page?
says page 18. of permit file volume 1.
Yeah,
Okay,
What does it say there after the
It's-
initials?
it says provide a survey less than 1 year old with seal by professional surveyor with dark dimensions delineated on the survey.
So is that doc?
Oh, that might be, yeah, with doc dimensions delineated on the survey.
Because this is the plan review routing slip for the doc permit.
This is the plan review permit for the doc permit. But Christy, I have to tell you, one of the reasons why we didn't have the seal was because the original with the seal had been sitting in an office at the initial submittal. And that was why we requested an updated survey so that it would meet the 1 year threshold that she mentioned, and so that the seal that she had requested was there. When I compared the surveys with what had been originally presented, what had been resubmitted, short of the sign and seal and the date, they were exactly the same.
Okay. So in the email from Clarice Hayes to you and Jeff, she confirms the intake date as March 27th, 2019.
No, I believe she confirms it as March 7th. I'll check. Let me
Let's go back.
see.
Let's go back. Yeah, let's go back and look at those emails.
So the permit was created on the 7th. That was when it first came in. There's something incorrect on the application. It wasn't completed properly. So there's a new routing slip or a new date implemented on the sheet that says date in, new information, 3/27/19. For whatever reason, because the routing sheet was with the original submittal, we had to create a whole new routing sheet. You'll see it in one of the documents. It's very clean and only my comments are on it. That's why you have two routing sheets from, you have a routing sheet where Ann is on it and a routing sheet where I'm on it, because the original routing sheet was in the office. There's another, I don't know if you can see on page 18, somebody even went so far as to kind of white out dates on the routing sheet. It just was a lot of weird stuff happening with this particular submittal. There are more than one routing sheets to go along with it.
Let me direct your attention to page 13 of Permit File Volume 1.
Yes, ma'am.
In the original email on the issue of the intake date, Jeff is asking if the intake date is March 27th. Is that right? Am I reading that correctly?
Please provide the intake date of the permit application 1907746. The routing sheet states date in 3/27. She then responds and says that is the correct date. The permit was created on 3/7/19 in the computer, but the application wasn't completed correctly and the customer was instructed to return with the corrected information. So our intake date is the 7th. There's some tolling that appears to happen, and then there's some information that goes out and comes back in on the 27th. And so she is confirming that the intake sheet or the date on the intake sheet is 3/27, but that the permit was created on the 7th of March.
Okay.
Can I jump in just because I'm trying to understand here?
Sure.
So you're saying that that this is all basically the email, the two emails that we're talking about, that is basically reverses is what it sounds like.
Right. You've got to read it from the bottom up to follow the trail. But okay. The problem with this particular one is I don't want to speculate, but this is what's happening. Jeff is inquiring or implying that the permit had recently just come in on the 27th, and he wanted us to start taking into consideration the toll dates from the intake date from the 27th. But in actuality, this had come in on the 7th. There had been an issue with the application. The application was then corrected. All of that stuff is typically laid out on a routing sheet. However, there's a single routing sheet that just has the information from the 27th. So he's trying to follow up and say, is this date that you first got this application on the 27th? And her response is, well, we got the permit in. You can't get the permit in and create it without an application on the 7th.
But didn't you just testify that then there's a tolling of the application until they get the requested information? So
There
then
is.
your time starts March 27, 2019.
Objection, Your Honor, assumes facts and evidence. There's been no establishment as to, I mean, the 27th is the date zoning shows it in. There's been no evidence showing what date the building department got the corrected information.
1 second, guys. I just need to move my dog. I'm listening. I'm just muting the computer.
Your Honor, Clarice Hayes, who sent the email, is the Development Services Coordinator. She's not from zoning. She's identifying that the correct date for the intake date is March 27, 2019.
Yeah, I'm going to allow the question because I think this does need to get cleared up because the dates are a little confusing and you know, I think it's extremely relevant. So I'm going to allow this question to move forward.
Yeah, I would like the dates cleared up. I was objecting because she was assuming that nothing had been corrected until the 27th. And so I agree, it should be cleared up.
Yeah.
So lady, let me see if I can get this right to clear up the dates. The application, according to this email, came in on March 7th, 2019. There was apparently some request for additional information because the application, according to Ms. Hayes, wasn't complete. Do you see that in her email?
Oh, I see the email, but it is important that I call your attention to page 4 because—
Wait, let me just stop you and I'll let you cover everything. I just want to try to get a short time frame down. So are we in agreement that March 7th, 2019 was the date the application came in?
It was.
Okay. And are we in agreement that this email from Clarice Hayes said because it wasn't complete, the intake date is now March 27, 2019?
I'm trying to keep it very clean, Christy.
Right.
And so this is what I will say. Clarice was a subordinate in a clerk in the department, very aware of what we were dealing with regard to this permit. Page 4 of the original routing slip, which was dated March 7th, which also had all of the original documents signed and sealed, had gone into or come into the building department. And that routing slip, based on 3-7 and all of the information that came with it, was sitting in Jeff's office. It was just sitting. We had, and I had kept a copy of the application noting the deficiencies as it pertained to the building department and what we would have cited as a deficiency on the application. I gave that information back to Clarice to provide to Mr. Taylor to make the correction. Because we didn't and could not get a hold of the original application, which was sitting in an office, we created a new routing slip. When we created the new routing slip, that was then returned or given to Ann, a person in zoning, not Jeff. She was new in the department. She didn't have any knowledge really of what's going on. She picked it up and reviewed it and cited the deficiencies for the survey. Okay. So the routing slip that you have that has 3-7 is the routing slip indicative of when it first came in. Clarice was not in a position to put into writing that Jeff was holding it in his office. And so this is a very clean response to what's going on.
Well, doesn't Ms. Hayes' email indicate there was something wrong with the application? She doesn't mention zoning, does she?
She can't mention zoning because she can't see the application. I'm not familiar. The only thing that would typically be wrong with an application is it's missing a contractor number or something that would allow them to identify or QA it at the end for issuance.
Okay, so
she doesn't have that in her hands because she can't get it in her hand. So now Jeff is asking her in this email, verify that this permit didn't come in until the 27th. And as opposed to saying, yes, sir, you're right. She says, well, yeah, you're right. There is a date in intake date. What she should have said is there is another routing slip in your office. You have the routing slip now because it's a part of the evidence package you've submitted that has 3-7 on it. Those things aren't generated unless the application is there and under review. There's no deficiencies listed on that routing slip until we get down until well after I believe I'm gone. So we couldn't get a hold of the original application because it was being held. So he's asking her to confirm that the 27th application is the only application, or not only, but that's when it came in. And she's very well aware of the fact that an application came in on March 7th, that there was some issues with it. And then we have a conversation and she goes into the fact that, yeah, you're right. There is an intake sheet that says this application was taken or the date in is 3/27, but that's another routing slip that's been recreated.
Okay, is it your testimony here today that when this application came in on March 7th, 2019, it was complete?
That is not my testimony.
So what was wrong with the application when it came in on March 7th, 2019?
We would have to ask Clarice directly what was wrong with the application on 3/7. Here's what I'm trying to communicate. The application would not have come into the department, stayed in the department, had a routing slip for it, and there not have been a reason for what was wrong with the application not written on the routing slip. But there's a void of 20 days because we don't know what happened. I don't know if the applicant, you would have to ask Clarice what was the problem with the application because I cannot recall.
Okay, so if we go to page 18 of Permit File Volume 1, it's the orange routing slip.
Right.
Under the zoning, what's that first entry about?
Let me get back to 18.
Page 18.
Yes, sir.
Okay, ask me the question again, Christy.
Looking at that on page 18, under zoning, there's a first entry there, March 27, 2019. What is that entry about?
That is the request from Anne that says the survey is less than, they need a survey that's not older than a year, and they needed a survey that is signed and sealed but that has the dock dimensions delineated on the survey. So she needed them to demonstrate what to not just have the boundary survey, but to show what the topographical conditions were going to be, the delineation of the dock. The problem was, if you go back to the routing slip, the original routing slip on page 4 in the other volume, I believe, you'll see, or you won't see, but what was behind that routing slip was the documentation that she's asking for, short of the updated survey on 327.
So wait, let me stop you there. If we go back to what you're saying is the original routing slip on page 4.
I believe so.
Permit file, volume 1.
Page 4. This is when the original one came in.
Right. So that has the initial, or the submittal date, 3/7/2019. So your testimony here today is that everything attached was complete except for the survey?
Except for the updated survey. Well, no, attached to this was everything they needed. It had the dock dimensions. It was the original survey. The date on it, though, would not have met the 1-year threshold that Ann DeVoe originally called out on the 27th. But everything else was affixed to this, and somehow this permit was not in rotation. It was being held.
Okay, so is it your testimony here today that except for the survey that Ann requested, Mr. Taylor provided everything needed for this permit?
Yes.
All right. When you were the building official for Riviera Beach, when you would do a plans review, do you stamp stuff?
I would stamp every permit that went out of the building department as the final approval.
Do you stamp plans?
Everything.
Okay, so for this dock permit, with this application submittal, whatever came in, you would have stamped after you reviewed it?
We would stamp it at the point that it goes out to be issued at final review, yes.
Okay.
Judge, could we take a few minute break? We've been going for a couple hours now. I need a few minutes.
That's fine. I don't have a problem.
Okay, we can stick a marker right here, but be aware we're probably going to be running up on the lunch break in probably about 45 minutes. So
yeah, I only need 5-minute break.
Okie doke.
Okay, thank you.
in reviewing permit applications and the stamp you would use. Now, so on a permit application, when you stamp the documents, do you stamp every document that you review so it's clear that you actually reviewed that document?
It depends. If it's stapled together, we would do the first page. Sometimes we would do all of the pages. It really just depended. There was no rhyme and reason. The intent was to give the impression that the permit had been reviewed in its entirety. So most of the times we tried to stamp every page.
Okay.
But it's not uncommon if we hadn't stamped every page. It didn't mean that it had not been reviewed.
Right, but I would imagine with some technical building information, if they have plans showing specific building materials to be used, you would try to stamp that so it would show you in the future that you'd actually reviewed it.
One would imagine, but again, if the pages were stapled or fixed together, it was clear. Sometimes the pages are bound, depending on the complexity of the drawings.
Okay.
There may be an instance where a page was not stamped.
Okay. If I can draw your attention back to the permit file, volume 1.
Sure.
If we go to page 6.
Yes, ma'am.
Now, just so you know, page 6 appears to be half of a survey, and page 7 is the other page of it, so that you can look at them to have an understanding of what the entire survey showed.
Understood.
So on the top of page 6, there appears to be a stamp. Is that your stamp?
Yes, that's my stamp.
And so it is dated April 15, 2019. So that would be the date you issued the permit?
Yeah, that's typically the date. Yes, ma'am.
Okay. So then if we go down to page 8, there's a stamp there that has a line through. Do you see that?
Mm-hmm.
Was that got stamped accidentally?
Yeah, this one did.
Okay. And then if you go down to the next page, page 9, there's a stamp towards the top, which is actually the right-hand side of the document if you turn the view. Is that your stamp?
Yeah, both of there's 2 stamps on this document and they both belong to me.
Okay. And, all right. Okay. And that's the stamp that you would commonly use when doing your reviews?
Final approvals, yes. And Christy, so you're clear, I wanted to point out, I've tried to, be very specific about plan review, me plan reviewing these plans and me stamping them as final approval. What I did, and what was a common practice for me, so that I wasn't unilaterally plan reviewing people's plans or getting myself into a space that would ultimately be uncomfortable, I would allow the plan reviewers to review the plan. And if they indicated, or I saw a routing sheet indicative of the fact that they'd seen it and approved it, then I would issue and stamp the plans with a final approval signing off for it to be issued, me being okay with it being issued. And that's what that stamp represents, that everybody who needed to review it had reviewed it and approved it prior to me issuing the final approval.
And when you say that, are you talking about the zoning officials review?
It depends on whether or not the zoning officials review came into play. On this
let's talk about this dock permit.
Yeah.
On direct, you testified that you went ahead and issued it because in your determination, they had satisfied your concerns.
And that was essentially what I was going to respond with just before you cut in. It wasn't uncommon for me to issue a permit, sign off on it. If it didn't have to go to zoning, if the requirements had been met, we would stamp it final approval because it had gone through all of the different departments and we were satisfied. This is a permit that we were and had quite a bit of information to speak to why this permit was being issued absent zoning approval.
And your issuance of this permit was in your role as the building official for the city.
Right.
Did you issue a permit under the city's wetland preservation ordinance for this dock?
No.
Objection. There's been no showing that a permit was required for the wetlands preservation area for this dock.
Your Honor, she's already testified that she's familiar with the wetland preservation ordinance.
I'm allowing the question. She's already answered it, so the negative. So it's not a got a no moment anyway.
You can answer the question, lady.
Oh, I did. No was the answer. No was my answer, Mr. Ryan, and essentially no was the answer because it didn't come into play.
Gotcha. Okay, thank you.
Now, Ms. March, you talked about your interpretation of a final order in a lawsuit that Mr. Taylor filed against the city. And in discussing your interpretation, you talked about flat work. What is flat work?
Non-vertical, fill specifically, curbing, the driveway is flat. Flat work. I'm trying to think of a more layman term for it, but essentially it ends up being dirt, just horizontal work, nothing that's, upright. No. Okay. I don't think the court order referred to it as flat work, but that's what I interpreted it as.
That's a technical term of a building official?
Yeah.
Okay. All right. In your review of the wall, we'll call it the wall permit, and do you recall, was there a separate permit for the wall, a separate permit for the driveways, a separate permit for the pavers?
I want to say that the driveway and pavers would have been on one permit because it would have, I know that went to engineering. The wall would have, I believe, been on a separate permit. The late Mr. Rafael Guzman plan review that.
Wait,
So
wait,
yeah, I think they were on 2 different permits.
which, Guzman is a former.
Guzman worked for CAP, but he was a beloved plan reviewer that worked under me. He passed away shortly after I left.
Okay. And you previously testified on direct that the wall permit did not receive a zoning review.
No.
Okay. Do you know if the driveway and pavers, if that was a separate permit, did that receive a zoning review?
No, driveways, there had been some rule in the building department, kind of an unspoken rule. There was discretion that was always allowed and extended to the building official in terms of the routing, but driveways essentially went to engineering. And so that's where that permit went, to engineering for its approval.
Okay. Did you ever receive or review a permit to place rocks or riprap on the property?
I cannot recall a riprap permit, no. I will say this, I would have probably interpreted that as fill so long as it was on the upland had I received the permit though.
Okay, so under your interpretation of that final order, your interpretation is okay if they put fill on the property or riprap on the property?
As long as they didn't go into the jurisdictions that required additional approval, because the city had my interpretation of that order was that the city had decided that they weren't going to apply any special preservation designations to the property, and that they weren't, if they had applied it, that he was exempt, and that they would not, he did not need to come back for a permit unless it was required by the other agencies.
Okay. And in your review of the permits that Mr. Taylor submitted for the wall, the driveway, aprons, and the pavers, did you see any approval from DEP?
I had seen approval. Wait, you said what did you ask me? The wall, the pavers, the driveway. You did not ask me about the dock.
No. We'll talk about that in a second.
Okay. So no, I didn't see DEP approvals for those. But again, my presumption was DEP approvals wouldn't have been required because they were on the upland.
Okay. Okay. Did you review the FDOT application that was submitted for the driveway aprons?
I did a superficial review of the driveway, the requirements from FDOT. Reading them, speaking with Mr. Taylor, I didn't feel comfortable making that decision on my own. And so I rerouted that permit to engineering. I rerouted Mr. Taylor to engineering to schedule a meeting to discuss all of the information he had, all of the things that he wanted to submit, so that engineering could ultimately decide if they would approve it. And I did agree that if engineering was okay with it, having had reviewed FDOT requirements, that I would issue the permit.
Okay. And do you review in your initial review of the driveway permits what they said the driveway was for?
They said they needed a way. They wanted some additional curb cuts. Something was going on next door to that property where FDOT was negotiating with them anyway about filling in this little piece of property that they had that sat right next to it. And he essentially just said there was no outside of parking on the street. There was no way to drive up onto or approach his property absent installing this amenity. And so that was the reasoning that he provided.
Do you recall him stating what the use of the property was for?
For him?
Yeah.
Dan Taylor.
Right. Do you remember that on the application, if they stated what the use of the property was for?
I cannot recall. The presumption would be now that it was, I believe it's his homesteaded property, so.
So would it have said a floating home?
I'm sorry. No, you just would have, on the description, most of the applications that come into the building department are very, very vague. So I don't know that he would have listed floating home on the permit that he was requesting for a driveway.
And on the permit for the dock, do you recall any documentation that were submitted with that complete application except for the survey that referred to the floating home?
No. Mm-mm. There was emails that I would send back and forth that did that, but based on the way you've asked the question in terms of the application, no.
And are you testifying here today that the floating home for Mr. Taylor was in place in March and April of 2019?
Mm-hmm. It absolutely was.
Okay. And do you know how long it was stationed out there?
I can't remember. I know as they started getting, I think he moved it right before storm season. But again, I left in April. I believe that floating home was present when I was separated from the city.
Do you know when it first appeared?
Oh, I think we probably started getting those calls late January, early February. I don't know if that's when it appeared, but I do recall getting an influx of calls from the neighbors not happy about it being there.
And are you familiar with the properties along Pine Point Road near to this property?
Yes.
And you're familiar that you spoke about Mr. Kant, that he owns a property on Pine Point Road?
Yes.
And do you know if Mr. Taylor signed off on the temporary electric pole permit?
No, is it in the documents that you gave me?
It is.
Well, let me look.
I think it's towards the bottom, page 24 of permit file, volume 1.
24?
Mm-hmm.
Yeah, it looks like he signed off on the temp pole.
Okay. And when did your tenure as the city's building official end?
April 29th
Of
2019.
Okay. And if due to the size of the dock that Mr. Taylor applied for is more than 30 feet, you would then characterize that as a commercial dock?
It depends on if how many slips he had and whatnot, but I would, well, no, I wouldn't. I'll take that back.
Okay.
I'll correct that statement.
On direct, you mentioned that you thought someone had what you would consider a commercial dock on a nearby piece of property because it was over 30 feet.
I did say that. I just said I'll take that back. I'll correct that.
Okay. So what is it? If it's over 30 feet, is it commercial or is it residential?
No, 30 feet I was thinking about the distance, but then I do recall that the slips and the amount of slips that it has is probably what's going to make the difference. And so I can't speak to what Mr. Kant's dock is. I think the thing that stood out the most to me about Mr. Kant's dock is that he had a dock and didn't have a primary structure on the property. That was really the point that I was trying to make.
And were you involved in all at the review of Mr. Kant's dock?
No, but what happened was I got the paperwork associated with the dock and pulled it for research because I was really looking for an out to not approve Mr. Taylor's permit to get out of the mess. And so I saw Mr. Cant's permit and I saw who had approved it. And I researched the relationships and whatnot. And as I started digging, I was able to clearly see what the course of and how it came about that he got the dock.
Okay, and in your research, did you look at all the emails that might have come in while
I
that?
looked at a substantial amount of emails, yes.
Oh, okay, so you looked at all the emails, you looked at the official building file. Did you talk to zoning about it?
No, I didn't. I mentioned it once, and it was kind of a shrugging of the shoulders. The only thing that I was really concerned about with its issuance is I wanted to know how Mr. Kant had signed off on the permit and its issuance. He was at the time the city's engineer, and I was trying to figure out the separation between the two and how he had had the opportunity to approve his own dock.
But you didn't discuss it in depth with zoning and how it got approved through
As
zoning.
I began, again, when I decided to bring it up, Jeff kind of looked at me blankly. There was a shrugging of the shoulders. And so it was a dead conversation. But I could follow the paperwork.
But you didn't go any further to look back at perhaps there was a planning and zoning meeting, perhaps there were other meetings associated with this dock.
I saw the meetings. I saw the meeting minutes. I saw some of the emails.
So they had official meetings on it.
I didn't say that they didn't. What I said caused me pause was his ability, even with the meetings, even with the approval. It would be like me signing off on my own new construction home as the building official. Most people would remove themselves from that process. He signed off on his own dock.
You took issue with Mr. Cant signing off on his own dock.
I did have an issue with him signing off on his own dock, but the issue beyond him signing off on his own dock was that it was essentially a dock that was approved, approval from the council or not, it was approved, and it did not meet the ordinance requirement in terms of not having a primary structure there. And I wanted to know what the difference was.
Well, isn't the dock right across from his property?
It's not on his property.
Do you know?
It doesn't matter that it's across from his property. Okay. At the time, it wasn't on his property, a property that he owned. I don't know what the circumstances are now, but when I looked at it, I thought that it was strange that he had a dock that he had applied for as a resident, as an accessory structure to his primary residence on a piece of property he did not own. I saw a couple of deeds where he indicated that he was asking for ownership of the property, but he didn't quite have it. And he signed off on it, and that caused me pause. I couldn't understand if that was okay, what the issue was with us issuing a dock for a floating home that needed to be anchored in the same lagoon that was so pristine that everybody was uber concerned about. It didn't make sense to me.
Based on you finding some issues in Mr. Cant's dock, you then went ahead and approved Mr. Taylor's dock permit without zoning approval.
Based on that, based on the emails that I saw between Ms. Pardo and Mary McKinney saying, listen, don't let these people develop this. We will say this is an environmental issue. Christy, there was a mound of information that they had presented to me that indicated that it would not be smart for me not to approve a dock permit for someone who had clearly identified that he had a residential structure in place, someone who had clearly identified to me and I could see where he had applied multiple times, and the only conditions that they disapproved the permit for that they stated had now been met. I issued the permit based on those reasons.
Okay, so no zoning approval.
No zoning
Objection, Your
approval.
Honor. Zoning had already commented, and the applicant had complied with zoning's comment. Ms. Cadeau's question assumes facts that are inconsistent with what's been established by the testimony, that zoning hadn't had a chance to comment. In fact, the evidence is they did, and that their comment was satisfied. So to say no zoning approval is a disingenuous question. I object to it.
And Your Honor, if I may respond to that objection, we don't come to this hearing and leave our common sense at the door. If zoning asked for a survey with specific dimensions on it, the reason zoning is asking for that survey is to review the survey. So if they are not allowed to review what makes supposedly an application now complete, according to Ms. March's testimony, then this permit was issued without zoning approval. And so my question to Ms. March, to try to get her to specifically answer a question, is did this dock permit receive zoning approval?
I mean,
Christy,
the
can
simple,
I admit?
hang on a second, Miss Lady. The simple resolution is if she knows, she knows. If she doesn't, she doesn't. So I'll allow the question to the extent that she knows.
I approved the dock permit. I checked the box in terms of it having been approved by zoning. It had been looked at by zoning. It had been approved by me, the building official. The zoning requirements that were being asked to have been satisfied have been satisfied. The survey that was requested was exactly the same, short of the updated date that she'd asked for. The dimensions had been laid out, and that was her concern. Prior to that, the concern was from zoning that there was a residential structure in place. There was a residential structure in place, evident by the floating home present. And so if the question is, did someone in zoning issue a final approval for the permit? The answer to that question is no. If the question is there zoning approval? I approved it via zoning as the building official, much like many building officials prior to me had done in the past for situations where those items were clearly evident that they could be satisfied. And on top of that, Mr. Gagnon wouldn't tell us what the additional issues were. He kept saying that there were deficiencies. He did not list them. At least Ms. DeVoe took the time to tell us what her concerns were. They were not nearly as extensive as they have become post my departure. Her, as a representative of the zoning department, her only concern was to ensure that she had an updated survey within the year, and that survey showed a signed and sealed professional engineer affixed to it, delineating the boundaries of the dock, which had not changed.
And in your review of all of Mr. Taylor's permits, the permit for the dock, the permit for the wall, driveway, and parking pavers, that would have been in accordance with the Florida Building Code at the time.
Yes.
Your Honor, I don't have anything further from Ms. March.
Go ahead, Mr. Ryan.
Okay. Ms. March, or lady, if I might, we saw that the dock application routing sheet, the one located at page 18, showed that it got into the zoning department on March 27th, 2019. And I believe that's the same day that you got the comment asking for the updated survey. Is that correct?
That's correct.
Let me just go down here to 18 real quick. I apologize. So, and then, okay, so on March 27th, Ms. DeVoe asks for, gets the zoning request. On March 28th, 19, Ms. DeVoe asks for the updated survey. It says date out, March 28th, 19. Do you see that?
Yes, I do.
Okay, and then we go up to page 6 of that same set of documents, and we see the stamped survey dated April 1st, 2019. You see that?
Yeah, I was looking for the sign. I mean, the seal.
You've got a signature of 4/15, but the surveyor's date of the survey is April 1, 2019 in the bottom.
Yeah, I do see that.
Okay, so sometime between March 28th, 2019 and April 1st, 2019, Mr. Taylor responded to the comment and turned around and complied with the comment and provided you with the survey that met Ms. DeVoe's concern.
Yes.
Okay, so the tolling period as a result of that deficiency would have been from March 28th until April 1st, correct?
I presume so, yes, sir.
Okay. And because of missing comments, if there were any deficiencies between March 7th and March 27th, because of documents missing from the city's file, we don't know what those deficiencies might have been.
Objection, Your Honor. I haven't heard any testimony that there's missing documents in the city's file.
Mr. Ryan?
She testified that the original routing sheet was being held and that they had to create an additional sheet, and that all of the documents attached to the March 7th document routing sheet would have shown numerous things, but obviously all of those things that would have been attached to the March 7th routing slip aren't part of this file. So I think it's been very clear that those documents were missing.
Well, I'll allow her to answer the question with respect to what documents she thinks were there or that she knows were there.
Well, let me see if I can clear it up just so we have a clear record.
Or whatever's in our knowledge of it.
Okay, Ms. March, are the document, going back to page 4, does this file contain all the documents that would have been attached to that routing slip?
It does not, sir.
Okay. And if you had those documents, would you be able to tell whether or not there were any deficiencies in the original application?
Yes, the deficiencies that I believe, I'll take that back. Off the record and not in writing, my conversation with or between Jeff and I about the documents that he had were relative to prior DEP approvals, prior approvals to Army Corps approval for this dock. All of those documents, which were a part of the original file from March 7th, I don't see here. It's not in the things presented to me. The bigger question is, why are there two routing slips? Why is there even any confusion between a routing slip from the 7th and a routing slip between the 27th? Why are there two routing slips for one dock? And the answer to that question is, you don't get a routing slip unless you submit an application and it begins routing itself through the department. At some point, the documents associated with the 3-7 routing slip, we could not get our hands on. We were aware of the comments because they're in the system. They are gone out of the system now. Well, they were when they're not there. The comments that are on the routing slip typically match the comments that are in the system on the file. That's how Ms. Clarice was able to go back confirm what the issue was, that there was a date or something wrong with the initial application, because she's reconciling that with the information that is also in the computer, transformed or transferred onto the routing slip. The fact that there is 2 routing slips for one dock and there's 20 days in between is not indicative of it tolling and there being just some information missing. The file was missing and all of the content associated with it. I had looked through the file originally when it was submitted for major items that I would have requested, which would have been the original DEP approval for the dock, what the survey looked like when they requested the DEP approval, the Army Corps engineering approval, all of that stuff was there. Jeff's argument to that, still having the file in his office, was that the process had changed. The DEP approval process was now a self-certifying process. When it was applied for under the Joan B. Trust and not Dan Taylor. It got so convoluted that the only thing I knew to do was to go back and refer to all of the items and deficiencies that had in fact been noted by zoning up to that point, and then make a decision, because it had indeed gone past the 30 or so days. And the 30 or so days didn't say we had to make the issue. It said that you had to give a reason for the denial, other than the reasons that you've already given that have been satisfied. Jeff's response to me was, we will come up with deficiencies in the near future. There are still deficiencies that exist. I called out in the memo what the statute said about not clearly stating what those deficiencies were, and therein lied the impasse.
Okay, and so just to be clear, the 30-day time frame that you're talking about was with regards to the time to be specific with Mr. Taylor about deficiencies in his application.
Or issue the permit.
Gotcha. Okay. I have no further questions, Judge.
Your Honor, I do have some follow-up.
Okay.
May I?
Yes.
Thank you.
Sorry. I keep trying to keep the background noise down.
Lady, you just mentioned about the 30-day deficiency, and that's from the statute we talked about before, 553.79.
Yes, ma'am.
And what happens if you hit that 30-day time frame?
Again, there's caveats to the 30-day time frame. They talk about there being unusual circumstances and that allowing you to go beyond that 30-day time frame. But the statute is very specific about listing the reasons in which you're not making any forward progress.
Okay.
And that is what I was pointing to specifically when mentioning the 30-day time frame, because all of the language is embedded in the same paragraph. And so not to omit a little bit and have a little bit here, I included the entire paragraph and pointed out to Jeff that not only are we tolling, we've gone past the 30 days, you have not mentioned you have not specified what our unusual circumstances are. And as a result of that, I'm issuing the permit. But on that same piece of paper that you had me refer to, Christy, that talks about the fact that it's being issued, I make it a point to make notes on the routing slip and everything else that zoning had been bypassed in terms of an in-depth review. And I put on there why. I affixed the memo. I try to do a good job of checking all the boxes as to why zoning didn't have an opportunity to go any further, because when the opportunity was extended, they didn't give us any reason to sufficiently deny the application.
Okay, and on the routing slips, are the other departments that it goes through as responsive as you are in terms of marking all of the appropriate boxes?
I don't know that I understand the question. You said on the routing slip, are the other departments are you asking, are they taking as good as notes as I was trying to? Like what, I don't
Well,
understand.
if your testimony is that you try to check off all the boxes that are applicable on the routing slip, my question is, do the other departments do the same thing?
They tend to.
Okay. Your Honor, Mr. Ryan sent over documents via email to you and myself, and I would like to use those documents to address the issue that Mr. Ryan has brought up with Ms. March, that there are missing documents. So I'm going to forward to Ms. March those documents that were provided by Mr. Ryan and to her attorneys.
Okay. And I can't remember if it was this hearing or the other one, but I'm going to go ahead and allow it just because we've done this informally with respect to, you know, laying foundations and admitting evidence. We just kind of agreed to admit evidence. So yeah, that's fine. Go ahead.
Okay.
Your Honor, if I may,
Sure.
It's 11:54, and I know we sent over quite a lot of documents to Mr. Guy that she's going to start bringing up. It might be a good time for a break because if we're going to go into a whole new line of questioning,
It might end up being another hour. I get it. Ms. Godot, how do you feel about that? I mean,
that's fine. That's fine. I don't mind going to lunch and taking a break now.
yeah, this is kind of a good point to do it if you're gonna, because these documents are new, and just for the party's edification, I didn't look at any of them. I saw the emails, but I didn't look at them.
Okay. And I'm going to attach to the email that I just sent to Mr. Ryan, lady and her attorneys. I'm going to attach the documents that Mr. Ryan sent along with his email that was attached with those documents.
Okay.
Okay.
Okay. So we'll go ahead and read this.
They should get those in while we're at lunch, and then we can go from there.
Yeah, and we'll get started back up at what is it? Just about 12. Let's say 1:15, I guess.
Okay.
All right.
thank you, everybody. I apologize, Miss March, for it taking so long, or lady for it taking so long, but we'll be back at 1:15. Thank you.
Thank you.
Okay, we're in recess.